Hello, I am Dr. Manvendra Kumar Tiwari, and I work as an associate professor at the Dharmashastra National Law University, Lucknow. Today, we will discuss Article 20 of the Constitution of India as part of our legal reasoning discourse in respect of the common law admission preparations. As you can see, Article 20, the marginal note of Article 20 reads, protection in respect of conviction for offences. We will see what Article 20 says in detail in the next slide. So, as you can see, protection in respect of conviction for offences. So, Clause 1, Clause 2, and Clause 3, these are three clauses which are there in Article 20. I am putting it as passage 1 so that the questions can also be based on the same. So Clause 1, if you look at the nature of Clause 1, Clause 2, and Clause 3, you will find that Article 20 in different clauses deals with three different rights. And all these three rights are in respect of protection from criminal actions of the state. By criminal actions, we mean this is in respect of criminal laws which provide for offences and the prosecution and the trial thereof. So there are some protections which are available in the form of fundamental rights. So what is important is that these protections are not ordinary protections from criminal cases. These are in the nature of fundamental rights and therefore cannot be tinkered with by the state. Article 359 of the Constitution of India, as amended by the 44th Constitutional Amendment, now says that Article 20 and 21 cannot be suspended even when a proclamation of emergency under Article 352 of the Constitution of India is invoked. That means 20 and 21 rights mentioned therein are non-derogable. So that also tells us the significance of Article 20, that apart from Article 21, which deals with right to life and personal liberty, the rights mentioned only in Article 20 are non-derogable even during emergency. So we'll see what is there in Article 20. So Clause 1 says, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. So if you look at Article 20, Clause 1, it actually talks about two things. First, that no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, charged as an offence. So, what it is saying that if a person is to be convicted, and conviction will follow prosecution. So, if a person is to be prosecuted and convicted for commission of an offence, that offence must be an offence in the law on the date on which an act which amounts to that offence should have been committed. So, what it therefore is trying to say is that an act which is not an offence today, tomorrow, the same act cannot, by way of retrospective lawmaking, be made a criminal act. This is what the first part of Article 20 says. I can only be prosecuted and punished for an act which is an offense at the date and time when that act has been committed. Okay, by a subsequent law, through retrospective operation of the law, the act cannot be made a criminal act, and hence I cannot be prosecuted and convicted for the same. Now we look at the second part of Article 20, Clause 1. says, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the crime. So the second protection is that even though an act is an offense on the date and time when that act has been committed, the punishment for that act cannot be increased again by a retrospective law. That means only the punishment that was fixed as per law for the commission of a crime or offense, only that punishment can be given. So a subsequent legislation cannot by retrospective effect enhance or increase the punishment for an offense. So this is the second part of Article 20, Clause 1, which is collectively known as the principle of protection from the ex post facto law. Ex post facto, that means retrospective law. But what is important is that this protection is only available in case of criminal law, that is, in respect of offenses and in respect of punishment for the offenses, not applicable to civil suits or civil cases. No person shall be prosecuted. Now we'll come to clause 2. No person shall be prosecuted and punished for the same offense more than once. Now, this is what is known as the principle of protection against double jeopardy. No person shall be prosecuted and punished for the same offense more than once. That means for one offense is criminal laws, substantive criminal laws define what is an offense. So when an act would amount to an offense is defined by the substantive criminal law, and it says that for an act which amounts to an offense, there can only be one prosecution and one punishment. So there cannot be multiple prosecutions and more than one punishment for the commission of one offense. So this is also important, that if I have committed one wrong, I can only be punished once. For the commission of same wrong, I cannot be punished and prosecuted and punished on multiple occasions. So, and this is what we know as the principle of protection against double jeopardy. Now, the third one, Article 20, Clause 3, is this particular provision says that no person accused of any offense. Now, these terms are important. No person accused of any offense. So, the right is only applicable to a person who is accused of an offense, shall be compelled to be a witness against himself. That means no person can be forcibly be made a witness against himself. If the person happens to be an accused, I cannot be forced to be a witness against myself. This also in a way means that I cannot be forced to give evidence against myself. Okay. However, the meaning of evidence here is different, as we will see later. Moving ahead. So, protection from the ex post facto criminal laws, that is what Article 20, Clause 1 is about. Literally, an ex post facto law is simply a law that is retrospective. That is a law made after the doing of the thing to which it relates and retroacting upon it. Okay. Now here, before we proceed further, we should understand the meaning of these two terms, retrospective and retroactive. Now, retrospective means where a legislation, by making the operation of the legislation enacted to a past date, that is before the date of the date of enactment, provides for the changes in the law from past. That means from the past date, the law stands changed. So that is what you call retrospective. So a law enacted in February 2024 may say that the the law shall have operation from February 2022. That means from 22 to 24, February 22 to February 24, even though the law was not in existence, that is, the 2024 February law was not in existence, by retrospective effect, the 2024 February 2024 law, which has been given retrospective effect, would effectively mean that even in 2023, the same law which was enacted in February 2024 was existing, was the law of the land. So this is what we call retrospective. And retroactive is when a law that has been enacted today will be implemented from a back date. That means even though on the back date on which the implementation is being sought, on that day the law is different, yet because of the retroactive operation of this law enacted, even in the absence of the existing law be changed on that date, the retroactive operation of a law enacted would mean that the consequences would ensue in accordance with the law enacted, which has been given retroactive effect. The law will not change, but the consequence will be in accordance with the law enacted, and that is what we call retroactive effect. So literally, an ex post facto law is simply a law that is retrospective, that is a law made after the doing of the thing to which it relates and retroacting upon it. If it is retrospective, the obvious implication is that it will be applied retroactive. So every law that is retrospective, there is bound to be retroactive operation of it. However, every law that is retroactive may not be retrospective, because retroactivity is an obvious fallout of retrospectivity, but vice versa is not true. Such laws are generally deemed unfair because in the nature of the case, the person or persons involved in the behavior to which such law relates can have no notice when the behavior took place of such an after-made law which applies to it. So if I'm doing an act in 2024, in 2025, this act is made a criminal act by retrospective effect, I have no notice that my act is actually a criminal act, because only by a future law, by retrospective effect, is actually making my act criminal. And that's why there is no fault, and that's why such laws are deemed unfair. Unfairness varies, however, from case to case. Just a small example, which is not directly associated here, but when we study international criminal law, in international criminal law, for example, after the conclusion of Second World War, there was a Nuremberg International Criminal Court Tribunal constituted, wherein the people who were responsible for the for the crimes against humanity and genocide, especially in Germany, were prosecuted in those courts, in those tribunals. Now, one of the challenges which this such international tribunal like Nuremberg Tribunal faces, that is the legal challenge, is that many say that this is a retrospective application of a criminal law, because when that act was being committed, when those acts were being committed, those acts were not law. Those acts were not prohibited by law. Those acts were not offenses. Only later on that somebody is being made accountable for those actions. However, there is a contrary justification also for this, which says that certain acts are so imminently and so horrible that you don't need a formal black and white law to be told that what you're doing is wrong. And therefore, in such cases, the natural law theory is invoked, whereby a person is told that a black and white law is not required for you to be told that what you're doing is inhuman, what you're doing is criminal. So that is also the case. But so far as positive black and white law is concerned, even such prosecutions of war criminals may have this argument of retrospective operation of a criminal law. And that is why perhaps it was decided to have an international criminal court, that nobody can actually come up with the argument of retrospective operation of a criminal law. So far as, then this is insofar as international criminal law is concerned. We are not right now concerned about international criminal law. Nevertheless, the ex post facto principle is very much a debatable aspect of international criminal law as well. Moving ahead, beneficial changes in the law made retrospectively or retroactively may be accorded. An act may be retrospectively or retroactively be declared not a crime. So what is important is that though an act may not, which is not a crime, cannot subsequently, by way of a retrospective law, be declared a crime. But an act which was a crime at the time of the commission of the act, later on by a retrospective law, that act may be declared to be not a crime. So in that case, this is also a retrospective operation of a criminal law. But this retrospective operation of the criminal law is permissible because this is not adverse to the person, rather this is beneficial to the person. And because of this reason, this is not considered to be wrong and violative of the rights of the person, because the person is actually gaining because of such legislation. Likewise, the punishment for an offense may be decreased retrospectively or retroactively. So and this is also permissible. Again, this is beneficial for the person that the punishment prescribed for the offense is being decreased, and even if it is done retrospectively or retroactively, if the fact that it is beneficial for the person would mean that it is not violating the person's rights, and that's why this is also permissible. So beneficial changes are permissible. Moving ahead, prevention against double jeopardy. The rule of double jeopardy has a plethora of definitions attached to it and finds its roots in the English common law rule of nemo debet vis vexare, meaning a man must not be put in peril twice for the same offense, essentially aiming to prevent a person from being punished twice for the same offense. This rule, some may say, is devoid of origin due to its multiplicity of roots and citations in legal history. It's said to have always existed as if it were part of the natural law theory, from the Greeks and Romans in Justinian's Digest to canon law and code of Hammurabi. It simply has found itself in all these historic laws. So the passage actually tells us that this is not only peculiar to India, rather this is something which has universal acceptance, and so much so that it is difficult to even find its historical roots. Because wherever we see history, this particular protection against double jeopardy seems to be present. The idea was codified and introduced formally into Roman law through the Justinian Code under the reign of Emperor Justinian I and then Emperor of Eastern Rome, expressing the idea of barring a subsequent conviction for the same offense by a person by the governor. Canon law as early as 1857 AD. Canon law refers to the Christian clerics, the law that was in vogue during the times of the prevalence and paramountcy of the church in Europe. So the canon law as early as 857 AD stated that nobody, not even God himself, could be judged twice for the same offense. Fast forwarding to the present, we can find this rule imbibed in many constitutions across the world, being a constitutionally guaranteed right in the United States of America, Mexico, Canada, and in India, whereas in common law countries, it is found and implemented through statutory laws. Another important point to note is that this rule is purely limited to suits that are criminal in nature and does not prohibit defendants from being charged in civil court for the same offense. Okay. Because as I said in the beginning, that these are protections against the criminal actions of the state, and therefore it does not affect the civil rights of civil courts jurisdiction. Now, right against self-incrimination. The third, that is Article 20, Clause 3 of the Constitution of India. Section 3 of the Indian Evidence Act contains a very broad definition of the term evidence. Does the same definition apply here? It doesn't. The interpretation of the part of Article 20, Clause 3 is governed by State of Bombay versus Kati Kalu Avgar, which was decided by 11 judges, deciding whether or not handwriting samples and blood samples were within the pale of Article 20, Clause 3. The Supreme Court gave us the term physical evidence. By prefacing evidence in this manner, the Supreme Court excluded blood samples and handwriting samples from the mix. What is important is that Article 20, Clause 3 says that no person accused of offense can be a witness against himself, can be forced to be a witness against himself. By that, I told you that no person can be forced to give evidence against him who is accused of a crime. Now, the question is, if I am accused of a crime, do I have the right to stop the investigating agencies or the police from taking my blood sample or my handwriting sample? Because I think that by doing so, I might be giving evidence against myself. And that's why flowing from the right under Article 20, Clause 3 of the Constitution, I can stop the police from forcibly taking my blood sample and my handwriting sample. Now, as you can see, the Supreme Court's 11-judge bench in the state of Bombay versus Kati Kalu Avgar decided that blood samples and handwriting samples come under physical evidence, and physical evidence is not covered by Article 20, Clause 3. That means I cannot stop police from forcibly taking my blood sample or handwriting sample because this amounts to physical evidence, and the protection under Article 20, Clause 3 is not extendable to physical evidence. The logic essentially being that these materials were inherently immutable and were only being used for drawing comparisons with the material already collected during the investigation. So, what is the basis to exclude physical evidence from the protection of Article 20, Clause 3? Because the characteristic of these evidences are that these are immutable. Immutable means that these are not amenable to change. So my handwriting will not change, my blood composition will not change because I am forced to give it. Whereas compared to this, if Article 20, Clause 3 protection is not accorded even to testimonial evidence, then in that case, because of force, because of coercion, I may be forced to accept my guilt without me having committed the crime. And that's why my confession would be an extracted confession, extracted out of force and coercion. And that's why my oral account is not immutable in that sense. It is amenable to change when I am put under pressure or when a force or coercion is applied against me. That is why the Supreme Court interpreted that Article 20, Clause 3 protection is only available when it comes to testimonial evidence. That is where I am being made to be a witness literally against my own self, but it does not apply to physical evidence. Enter Selvi versus State of Karnataka, 2010 judgment of the Supreme Court. Decided by 3 judges, it considered whether an accused could be compelled to undergo either brain mapping, polygraph test, or narco-analysis test. 3 judges held that compelling a person accused to undergo any of these would violate the constitutional right under Article 20, Clause 3, because these are not physical evidences. Polygraph test, narco-analysis test, and brain mapping test, all these 3 tests are actually relying upon the testimonial account of the person accused. And these testimonial accounts, for testimonial accounts, there is a right available in the form of Article 20, Clause 3. And it has not yet been established by science that brain mapping and polygraph and narcoanalysis are actually capable of bringing out the truth from the mouth of the person accused. And that is why the court said that these cannot be covered. These will be covered under Article 20, Clause 3. Hence, a person cannot be forcibly made to undergo these tests. That's what this passage is about. Source is mentioned. This is by an Abhinav. This is an article published. Excerpts have been taken from an article published by Abhinav Shekri, researcher in criminal law, published on Indicon Law, which is the blog by Gautam Bhatia called Constitutional Law and Philosophy blog. So this is the source of this passage as far as Article 20, Clause 3 is concerned. Now we'll see a few questions based on what we studied so far. So first question, a law that is retrospective, that is a law made after the doing of the thing to which it relates and retroacting upon it, is a law against double jeopardy, law against self-incrimination, law, it is an ex post facto law, clearly. So option C is the right answer. Such laws are generally deemed unfair because in the nature of the case, person or persons involved in the behavior to which such a law relates can have no notice, can have no notice, can have notice, can have no notice. That means option B is the right answer. Decreasing the punishment retrospectively for a crime is permitted, prohibited, no, is not prohibited by the protection against ex post facto law. So clearly option B is the right answer. Repealing a law which provides for a criminal offense violates the law right against ex post facto, no, does not violate the right against self-incrimination, no. So option B does not violate the right against ex post facto. Repealing a law is all the more beneficial for the person. The act is no more a crime. So clearly does not violate the right against ex post facto law. B is the right answer. Nemo debet vis vixari is the basis for the rule of right against self-incrimination, right against ex post facto laws, right against double jeopardy. Clearly option C, right against double jeopardy, is the right answer. The right against double jeopardy is available in civil suits, no. Available in criminal cases only. Available in both civil suits and criminal cases, none. So option B, available in criminal cases only, is the right answer. Section 3 of Indian Evidence Act contains a very broad definition of the term evidence. Does the same definition applies in case of right against self-incrimination? No. No, because physical evidence is excluded from the purview of Article 20, Clause 3, even though the term evidence covers physical evidence as well. So option B, question option B is the right answer. In the state of Bombay versus Kati Kalu Augad, Supreme Court excluded physical evidence from the purview of evidence under Article 20, Clause 3. Yes, right. Option A is the right answer. Last question. In Selvi versus State of Karnataka, the Supreme Court decided that forcibly subjecting a person to undergo the polygraph test, brain mapping test, and the narcoanalysis test violates the right of the person under Article 20, Clause 3. Clearly, yes. So option A is the right answer. So with this, we conclude today's session. Thank you very much. See you soon in our next recording.